English shorthand 80 words per minute, passage number 25. Get ready. 10 seconds. 5 seconds. Start. The state of Punjab aggrieved by the order dated 7th of September 2005 passed by the Punjab and Haryana High Court in Criminal Revision number 320 of 2000, whereby it has set aside the order of the trial court dated 24th of January 2000 summoning the respondent Gurmeet Singh to face trial under section 319 of the Code of Criminal Procedure has preferred this special leave petition. Leave granted. Facts lie in a very short compass. On the basis of a report, a case under section 304B of the Indian Penal Code for short IPC was registered at police station Bathinda. In the first information report, the names of various accused persons figured, including Gurmeet Singh, the respondent herein. The police, after usual investigation, submitted the charge sheet in which the respondent did not figure as an accused. However, the respondent, along with some other accused persons who were not charge sheeted, were summoned to face the trial. They challenged the said order before the High Court in Criminal Miscellaneous number 1584 of 1999, and the High Court by its order dated 25th of February 1999 set aside the order summoning those accused persons, including the respondent, but while doing so gave liberty to take recourse to the provisions of section 319 of the Code of Criminal Procedure herein, after referred to as the code at an appropriate stage of the trial. During the course of trial, evidence of one Shakuntala Rani PW1 was recorded, who averred that the respondent herein was also responsible for the death of Gurjit Kaur, the wife of Paramjit Singh. Thereafter, an application was filed by the prosecution for summoning aforesaid Gurmeet Singh and other accused persons before the trial court in exercise of the power under section 319 of the Code. The trial court, by its order dated 24th of January 2000, summoned the respondent besides other accused persons to face trial for commission of offence under section 304B IPC, inter alia observing that the names of those persons figured in the FIR statement of the witnesses recorded under section 161 of the code and the evidence of Shakuntala Rani PW1 respondent challenged the aforesaid order in a revision application filed before the High Court inter alia on the ground that he cannot be tried for offence under section 304B of the code because he is not a relative of the husband of the deceased. It was pointed out that Paramjit Singh happened to be the husband of the deceased, whereas the respondent is the brother of his aunt and therefore cannot be said to be a relative of the deceased husband. Aforesaid submission found favour with the High Court and accordingly it quashed the order summoning the respondent to face the trial. While doing so, the High Court observed that even the dictionary meaning of a relative is one who is related by blood or marriage. Gurmeet Singh is certainly not related to Paramjit Singh either by blood or by marriage. Gurmeet Singh would not fall in the category of relative of the husband. Therefore, Gurmeet Singh must be excluded from the array of the accused. It is not necessary to try him under section 304B IPC for the dowry death of Paramjit Singh's wife, Mr. Madhukar, learned additional advocate general appearing on behalf of the state submits that the High Court erred in holding that the respondent is not a relative of the husband of the deceased. According to him, the High Court erred in holding that he is not a relative of the husband of the deceased. Mr. Singh, learned counsel appearing on behalf of the respondent, however, submits that the respondent cannot be said to be related to the husband of the deceased in any manner and therefore cannot be prosecuted for offence under section 304B of the IPC. The rival submission necessitates the examination of section 304B of the IPC, which says that where the death of a woman is caused by any burns or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand for dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. This section therefore exposes the husband of the woman or any relative of her husband for the commission of offence of the dowry death. Admittedly, the respondent is not the husband of the woman who died, and therefore the question which falls for determination is as to whether he comes within the ambit of any relative of her husband. Stop.